Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith-Rogers, producer of Public Health on Call. Today, litigation on vaccine mandates continues. Dawn Solowey, a partner in the labor and employment practice of Seyfarth Shaw, joins Dr. Josh Sharfstein to talk about what's at the heart of these court cases and their implications for other issues in the workplace, including diversity efforts and protections for LGBTQ individuals. Let's listen.
Dawn Solowey, thank you so much for joining me on Public Health on Call to talk about litigation around vaccine mandates. And I have to start with this question. There's still litigation around vaccine mandates?
Oh, absolutely there is, Josh. I spend most of my work time on vaccine-related issues, even today in 2023, and have since the summer of 2021.
And these are cases generally at the state level, would you say?
We have teams that are defending these cases all around the country in both federal court and state court, and also at the EEOC and equivalent state agencies. Many of them are still in the trial courts, but some of them have reached the appellate courts as well.
I'm getting a sense of the scale from the way you're talking about it.
Yes, some of them are very large cases, so class actions or actions with hundreds of plaintiffs, and then some of them are single plaintiff cases. It's really kind of all over the map.
So tell me the story of this litigation.
It really started in 2021, if we can all bring ourselves back to that time. At first, the vaccines were available, but still scarce. And then they became widely available, and employers started to think about whether to have mandatory vaccination policies. And in connection with those mandatory vaccination policies, employers set up systems where employees could apply for religious or medical exemptions. And what happened is that they were deluged with requests for religious and medical exemptions. So one of my areas of expertise for a couple of decades has been religious accommodation. And it used to be a very kind of sleepy little area of the law. Occasionally, firm clients would have questions about, I want to wear a yarmulke with my uniform, or I need to take a prayer break. And those were usually fairly easy to resolve. And then all of a sudden in the summer of 2021, we had employers who were saying, I have 50 requests for exemption. I have hundreds. I think one client had 15,000 requests for exemptions, and employers didn't really know how to process those because most employers had really, if they had ever dealt with them, they had only been in very small numbers. And they also just had this crushing volume. And so they were sort of reaching out to us to help. And then also requests for medical exemption. So people who are claiming to have a medical contraindication to the vaccine.
And so the employers have to figure out whether this is for real or not, basically, and are deciding whether to grant the exemption.
On the religious side, if an employee can show a sincere religious conflict with the vaccine, that's sort of a three-part test, sincere religious conflict, then the employer has to do an interactive process to determine if they can provide a reasonable accommodation without undue hardship. And then on the medical side, they were really looking at, has the employee presented an actual CDC contraindication in most cases to the vaccine, signed by a healthcare provider. And then again, can they make that, even if the person has shown that kind of real medical contraindication, can they make a reasonable accommodation without undue hardship?
So I imagine a lot of your work was setting up the systems for these employers to actually fairly review all of these requests for exemptions.
Exactly. Some employers did that themselves in-house. And we helped them set up the process. We were creating process maps to help them design those processes. Some employers said, we only have 5 HR people who are already busy and they cannot take this on. Can you do it? And so we were training up teams. At one point I was training teams of 20, 25 people every couple of days to get more people at the firm trained in religious and medical accommodation, and specifically in the environment of the COVID vaccine. Because, again, putting us back in that time frame, this is when there was misinformation and disinformation about vaccines. And you could buy religious exemption requests online for $25, $50. You could download them for free on some websites, including pastor letters. And so it was just really unlike any kind of request for religious accommodation that we had ever seen prior to 2021.
So you sort of hit the work lottery there.
That's the one way to think of it.
So some people get the exemption, some people don't get the exemption. And I imagine that some of these cases may be about what happened to the people who didn't get the exemption.
In most cases, the plaintiffs are people who were denied a religious or medical exemption. And, for many employers that had mandatory vaccination policies, in some cases, they would put people out on administrative leave and then ultimately terminate their employment. There are some plaintiffs who actually were accommodated in some cases, but they didn't like the accommodations. So they, for example, if they were asked to mask and test, they may also object to masking or testing on religious or medical grounds. But that's a smaller subset. I'd say most of the plaintiffs are people who were disappointed to have been denied.
And the employers involved include healthcare organizations like hospitals?
Some of the first clients that we worked with in the summer of 2021 were healthcare employers because, first of all, they're extremely knowledgeable about the vaccine, and many of the decision makers were physicians. And so they really understood the issues and the risk. And also they had these very vulnerable patient populations that they needed to protect. And at the same time, real concerns about, spread within hospital settings in terms of clusters of infection. And so those were among the first employers who were sort of reaching out for assistance on this. I would say also universities, because they had so many students who were living in sort of congregate settings and also needing to set up a process before the school year started. And, again, putting us back in that time frame, and I know this seems like a million years ago, but it was kind of the Delta surge, the fall and winter were coming, and concerns about sort of spikes at that time. There was a lot of urgency around getting people vaccinated by the fall of 2021.
Now, with so much immunity in the population and the decline in the number of deaths, I'm imagining some of those employers have given up on their vaccine requirements, but maybe the cases still persist?
Yes, that's a good point. So many employers have changed their vaccination policies since 2021 because, as you said, the sort of immunity picture looks different, the public health guidance looks different, and it was a very, very fraught and expensive process to manage so many exemptions. So that landscape has changed. I mean, I would say in particular, healthcare employers, many still do have vaccination policy because they still feel that that is what they need to do in order to protect, patients and the public. Outside of the healthcare sphere, many other employers have changed their vaccination policy over time. The litigation is not quick, and these are claims that are being brought under Title VII for religious discrimination, or the state law analog to Title VII, or under the Americans with Disabilities Act or state law analogs. And so under those statutes, you first need to go to the EEOC or the equivalent state agency. And so there was sort of a process in place where people were waiting for a resolution or a right to sue letter from those agencies. And then they went on to court. And so that's in part why, many of those cases have taken time to sort of grind through the litigation system.
So it sounds like there are some pretty basic legal questions of how the law applies to individuals, existing law. Are there any kind of broader questions that are coming up in this litigation?
One of the interesting things about this litigation is that it raises lots of issues of first impression in the law. And so the courts are really having to wrestle with that. I mean, as an example, so, I mentioned that a plaintiff in the religious space needs to show a sincere religious conflict. But there are a lot of thorny legal questions kind of packed into that test, right? So what is a sincere religious belief? And again, prior to 2021, we generally would counsel employers that you need to presume the sincerity of a religious belief, because you generally don't want to kind of try to get behind someone's claimed religious belief. And, do you really need to wear a yarmulke? Or that's just not something that employers want to be in the business of, or courts or juries want to be second guessing. But what does that look like when there are so many online resources to purchase where you can just download the whole exemption request right off the internet? And so that's just one example. Or what's a religious request? Like, where's that line between what's religious and what's political? What's just flat out misinformation about the vaccine? And then the concept of what is an undue hardship. Is it an undue hardship to have to allow an unvaccinated person to work in a healthcare setting, whether or not they have a sincere religious conflict? But just, is that an undue hardship if they're putting patients and other staff at risk? And, one thing I should mention is that the Supreme Court, in the middle of all of this, issued a decision, unanimous decision, in the case of Groff versus DeJoy in the summer of 2023, that pretty substantially changes the test of what is an undue hardship. And so in an already very complex legal environment, the standard changed from the old standard, which was an undue hardship is anything that requires more than a de minimis burden on the employer, to the new standard, which is, does it impose substantial additional costs to the employer in the light of the employer's business? And so in some ways, that's a fairly significant change. And so now the courts are grappling not only with all of the complex legal issues of first impression, but how do they interpret them in light of the Groff decision? So there's quite a bit going on in these cases.
Plenty to keep an employment lawyer busy.
Yes, lots of novel questions and novel theories.
Let me ask you this last question. Do you think that this litigation has implications beyond vaccine mandates?
I would say absolutely yes. For one thing, everyone in the public is a lot more aware of the fact that there is such a thing as a religious accommodation because of all of the intense, kind of focus on this over the last couple of years. And the Groff decision made that even more salient, I think, in the general population, that, I think it indicated an interest, particularly by the Supreme Court, in religious accommodation matters. So what we're seeing is a lot more religious accommodation requests coming into employers across the board, not just with respect to vaccines. For example, we are seeing a lot of requests where people will say it's a conflict with my religious beliefs to attend a diversity training, or it's a conflict with my Christian beliefs to participate in Pride Month. Or there was a recent case in the Seventh Circuit where a teacher said, I don't feel comfortable using students' preferred pronouns because of my religious beliefs. Employers are really seeing a lot more of those requests, and those are turning into litigation. And I think they're really challenging for employers because they are, in a lot of ways, kind of putting, some employees' religious rights in conflict with other employees' protected classifications, or with D&I initiatives that are very important to employers, for lots of reasons. And so we've set up a team internally that we call the Cultural Flashpoints team, because there are so many questions coming in, and social media, of course, magnifies all of these issues. But we're really seeing just heightened awareness of religious accommodation and more litigation in this space.
This sounds like an area of law that is going to be very important for public health. Dawn Solowey, thank you so much for joining us to tell us about it.
It was a pleasure to be here. Thank you for having me.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.